Hi, everyone. My name is Kruse. I'm an attorney and the owner of Kruse Family Law in Minneapolis, Minnesota. Welcome to our series, The Basics of Minnesota Divorce. The purpose of this series is to provide you with a very brief overview of some of the major topics that come up when you're getting a divorce in the state of Minnesota. This is not legal advice. I am not your attorney. This is not focused. It's very broad. Before you take any action in your divorce, talk to your own attorney. Today, we're going to talk about parenting time. Last episode, we talked about custody. In the future, we'll be talking about child support, spousal maintenance, property division, and attorney fees. Now, when we discussed the issue of custody, I mentioned that physical custody really doesn't have a whole lot of meaning in Minnesota anymore, and that's true. What really matters and what most people are concerned about is parenting time. Now, by statute, each party is presumed to receive at least 25% parenting time if the issue is raised to the court. If you don't raise this presumption to the court, then you may not get that parenting time. But if you do raise it, the statute says you're presumed to get at least 25%. Now, every day in a 2-week period is about 7%. So 25% would be 4 days out of a 2-week period at minimum. The statute is gender neutral. Now, I know there are people who say, divorce law, parenting time favors women. BS. It doesn't. In Minnesota, I have yet to be in front of a judge who has not been gender neutral on this issue. So despite what some people say, we are gender neutral in Minnesota. Now, the age of the children does matter to parenting time. Younger children can't be away from parents for nearly as long as when they get older. So the schedule you get when your child is 6 months or a year is not likely to be the same schedule that you have when your child is 16 or 17 years old. And parenting time schedules do change very often over the course of the child's minority. The trend in parenting time is towards 50-50, if the parents desire it. Okay. Now, in Minnesota, the statistics that I've seen suggest that we are, on average, very close to 50-50 parenting time. Again, some people would suggest that we're not, but the research suggests that we are actually very close to that. Now, as with custody, we're going to look at some select best interest factors. These are not all of them. Go check out Section 518.17 of the Minnesota statutes if you want more information. And these are going to be the same interest factors that I talked about during custody. First, the child's physical, emotional, and other needs. Are you able to nurture your child, basically? Second, are there special needs requiring special arrangements or services? Do you have an accessible home if your child is in a wheelchair, as an example? Third, the reasonable preferences of the child. Who does the child want to be with? Now, again, as the child gets older, this is going to become more important. Okay, a 17-year-old with a car can leave if they want to. If your child is 5 or 6, this is not going to be really an issue at all. If your child is 12 or 13, this is going to be somewhat of an issue. If your child is 16 or 17, this will probably be a significant factor. Parental issues affecting child safety or development. If you have a drug habit, if you're an alcoholic, these are going to be issues. If you have mental or emotional problems that may affect your ability to parent, that can be an issue. The history and nature of parental participation in child care. This is important, particularly for younger children. If only one parent takes responsibility for getting the child out of bed, getting them fed, off to school, getting them dinner at night, getting them into bed at night, that person is going to be more likely to have more parenting time. If both parties have done these things, then you're more likely to get a more even split. The effect of the proposed arrangement on the child's relationship with significant others. This can be especially important if the parents live at a distance from one another. But how are you going to keep your child's relationship with grandparents, with step siblings that may be their aunts, uncles, other family members, things of that nature? Are you willing to support the relationship with the other parent? That is very, very important. If you're not willing to support the relationship, you may find yourself lower down on the amount of parenting time that you get. And then the willingness and ability of parents to cooperate in child rearing. Cooperation is very important. Judges like cooperation. If you give the judge the impression that you are not willing to cooperate, you may not get as much parenting time. These are just a few of the issues. This is a very brief overview. If you have a family law question, take a look at our website. We do have a lot of resources on there, links to things that may help you out. Give us a call at 612-231-9865 or shoot me an email, corwin@krusefamilylaw.com. Thanks for watching. I hope you found this useful and interesting. Have a good day. Thanks again.